When Justice Alito tried to publicly silence Jasmine Crockett inside the Supreme Court chamber by interrupting her 3 times, he had no idea he was walking into a trap. Because seconds later, Crockett pulled out hidden historical records, dropped a devastating data bomb, turned the Supreme Court chamber into a public battlefield, and triggered the most explosive constitutional confrontation America had seen in years, and forced the Chief Justice to intervene. The Supreme Court chamber in Washington, D.C. was packed beyond capacity, not with tourists or routine observers, but with reporters, civil rights leaders, and legal experts who all knew this was not an ordinary hearing. This was a nationally televised constitutional showdown over one of the most explosive issues in America: voting rights. From the very first minute, the atmosphere felt charged. Crockett stepped forward and didn't waste time easing into it. "Mr. Chief Justice, and may it please the court," she began, her voice steady but firm. "The right to vote is not a favor granted by the state. It is the foundation that holds every other constitutional freedom in place." The room stayed quiet as she laid out the human cost behind the case. Thousands of eligible voters blocked by technical rules, long lines, paperwork traps, and requirements that hit poor and minority communities hardest. This wasn't abstract theory. She spoke about real people who showed up ready to vote and walked away empty-handed. As she spoke, Justice Elena Kagan gave a small nod, recognizing the legal structure behind the argument. Justice Amy Coney Barrett leaned forward slightly, eyes fixed on Crockett, listening closely. Alito didn't wait long. He cut in sharply. "Counsel, let's be clear," he said. "Article 1 of the Constitution gives states the authority to regulate elections. That's the plain text. You can dress this up however you want, but the Constitution doesn't change because you don't like the outcome." The words landed hard. His tone wasn't curious. It was confrontational. It was meant to end the discussion before it even started. A few people in the gallery shifted in their seats. This was the strike he had been waiting to throw. Crockett didn't flinch. She looked directly at the bench and fired back calmly. "Justice Alito, I'm not asking this court to ignore the Constitution. I'm asking it to read the whole Constitution." Her voice tightened with controlled intensity. Article 1 did not freeze election law in the 1700s. The Reconstruction Amendments fundamentally changed the relationship between states and the federal government. They were written because state power was being used to block citizens from voting. She paused just long enough to let the words sink in. That's not politics. That's constitutional evolution. The tension spiked. Kagan nodded again, this time more visibly. Barrett picked up her pen and started writing. Even a few clerks glanced up from their screens. Crockett pressed forward. "You call this plain text authority," she said, locking eyes with Alito. "But the plain text of the 14th and 15th Amendments exists for one reason: to stop states from using procedure as a weapon." Her voice sharpened. "If this court pretends those amendments are optional footnotes, then we are not interpreting the Constitution. We are selectively protecting power." Alito leaned forward, visibly irritated. "Congresswoman," he said pointedly, stressing the word, "this court is not here to rewrite the Constitution to match modern political goals." The room reacted instantly. A low wave of murmurs moved through the gallery. Using her political title instead of counsel wasn't normal courtroom language. It sounded less like legal questioning and more like a public jab. Crockett froze for half a second, eyes steady, absorbing the hit. Then Crockett didn't answer Alito right away. Instead, she slowly reached down and opened the leather portfolio in front of her. The soft crack of the cover breaking open echoed through the silent chamber, followed by the sharp, unmistakable sound of paper sliding free. In a room where even breathing felt loud, that single movement pulled every eye forward. Cameras zoomed in. Crockett lifted it slightly, holding it steady, and said calmly, "Since we're talking about what the Constitution really means, let's hear directly from the people who wrote the rules you keep quoting." The tension tightened. No one interrupted her this time. She began reading aloud, her voice slow and deliberate. Senator Oliver Morton, one of the architects of the 15th Amendment, said the federal government must hold the power to protect voting rights because certain states had proven they could not be trusted with it. A few heads in the gallery lifted higher. She turned the page. Representative James Garfield warned that state laws would continue finding new ways to restrict voting unless the Constitution placed real limits on their authority. The words didn't sound like modern politics. They sounded like warnings sent forward in time. Crockett flipped again. And Senator William Stewart made it even clearer, she continued. He said the amendment was not just banning discrimination. It was creating a positive duty to make voting genuinely accessible. Each sentence landed heavier than the last. At the bench, Chief Justice John Roberts leaned forward slightly, eyes narrowing as he followed along. One of the cameras caught it, the Chief Justice physically moving closer to the evidence. Two law clerks in the front row exchanged quick looks, then glanced back at the document copies being prepared. The energy in the room shifted. This was no longer a debate about abstract theory. It was becoming a confrontation with historical receipts. Crockett handed copies to the clerk without breaking eye contact with the bench. The clerk accepted them carefully and began distributing them down the row of justices. Crockett raised her voice just enough to cut through the silence. These aren't blog posts. These aren't activist talking points. These are the recorded words of the people who designed the Reconstruction Amendments. She turned directly toward Alito. You've been telling this courtroom what the Constitution says. I'm showing you what its authors said it was meant to do. The room froze again, but this time the silence felt different. Heavier, sharper, charged with realization. Crockett paused, holding the document in place for one final second, and delivered the line that shifted the entire tone of the hearing. These weren't opinions, she said firmly. They were the architects of constitutional meaning. Then Crockett didn't argue theory anymore. She went for the numbers. She pressed the control on the podium, and the courtroom screen lit up behind her. A large chart filled the wall, bright enough that even the back row could see it clearly. This isn't speculation, she said, her voice cutting through the silence. This is what actually happened. She pointed to the tallest bar on the screen. In Jefferson County, 83% of the voters who were denied ballots under this law were minority citizens. A visible reaction rippled through the gallery. She didn't stop. Now look at the second number, she added, tapping the screen again. Minority voters make up just 34% of the county's population. Her tone sharpened. That is not balance. That is not coincidence. That is a pattern. She turned slowly toward the bench, letting the room absorb it. You've heard the state call this neutral, Crockett said. You've heard this law described as equal treatment. But when one group takes nearly all the damage, neutrality becomes a lie. Her eyes locked onto Alito. You dismiss this as inconvenience, she continued. You minimized it. You brushed it aside like paperwork delays don't matter. Her voice rose slightly. Tell that to the elderly voters who stood in line for hours. Tell that to working parents who couldn't take another day off. Tell that to citizens who followed every rule and still walked away without a ballot. The courtroom went completely still. Crockett stepped forward half a pace, refusing to let the moment slip. So I'll ask you directly, she said, staring at Alito. If this isn't suppression, what is? The words hit hard. Cameras zoomed in. Alito shifted in his chair, his fingers tightening on the armrest, but he didn't answer. Seconds passed. Then more seconds. The silence stretched so long it became uncomfortable. You could hear someone swallow in the gallery. No one dared to interrupt. Crockett didn't wait. This law didn't fail, she said coldly. It worked. It filtered voters. It narrowed access. It created barriers that hit the same communities over and over again. She tapped the screen again. And when a policy produces results this one-sided, this court has a responsibility to stop pretending it's accidental. Her voice carried anger now, controlled, but unmistakable. Calling this state authority doesn't make it constitutional. It just hides discrimination behind better vocabulary. That's when Justice Amy Coney Barrett leaned forward and broke the silence. "Congresswoman Crockett," she said carefully, "if this court accepts that these disparities matter, what standard should we use to evaluate laws like this?" The room shifted instantly. Heads turned. Even reporters stopped typing. Crockett didn't rush to answer Barrett's question. She took a breath, let the room settle, then spoke with a calm that felt dangerous. "When a voting law produces this level of harm," she said, "this court cannot treat it like routine regulation. It requires heightened scrutiny, real scrutiny, not polite approval dressed up as legal review." She turned slightly toward Alito again. "You keep invoking plain text authority," she added, "but you're only quoting the parts of the Constitution that support your position and ignoring the parts that protect people." Her voice dropped lower, sharper. "That isn't textualism. That isn't originalism. That is selective constitutionalism." The words landed like a shockwave. For a split second, the courtroom didn't react at all. Then it happened. Justice Clarence Thomas, who rarely showed visible emotion, slowly lifted his eyes from his notes. His eyebrow raised just slightly. It was subtle, but in that room, it was dramatic. A few law clerks froze mid-typing. Reporters exchanged quick looks. The phrase cut through years of legal debate in one clean strike. It wasn't just criticism. It was an accusation that the court itself was choosing power over principle. Before anyone could interrupt, Chief Justice John Roberts leaned forward and spoke. "Counsel," he said, his tone measured, "you may continue. We will extend your time." A quiet wave rolled through the gallery. Crockett stood taller at the podium, eyes steady, hands resting calmly on the edge. Then Crockett lifted her eyes from the podium and looked directly at the bench, her voice steady but carrying a weight that felt heavier than anything said so far. "This case is not about convenience," she said. "It's not about political comfort. It's about whether this court still has the constitutional courage to protect the right that protects every other right." The room seemed to shrink around her words. You could hear people breathing now. Slow, shallow breaths from the gallery, the kind people take when they know something irreversible has just been said. A clerk in the front row froze mid-note, then accidentally let their pen slip from their fingers. It hit the desk with a sharp click that echoed far louder than it should have in the silence. Crockett didn't stop. She leaned slightly forward and delivered the final blow. The framers of the 15th Amendment would recognize exactly what is happening in Jefferson County today, she said firmly. The real question is not whether the Constitution allows this court to intervene. The real question is whether this court is brave enough to do what the Constitution demands. The words hung in the air, heavy and unmovable. No justice spoke. No one interrupted. It felt like time paused inside the chamber. Justice Alito sat completely still. His posture was rigid. His hands rested on the armrests, unmoving. The same justice who had interrupted, challenged, and dismissed her minutes earlier now stared forward without speaking. His jaw tightened slightly, but he didn't reach for the microphone. He didn't push back. He didn't even shift in his seat. In that moment, the power dynamic flipped in front of everyone watching. The interrupter had been cornered, not by shouting, not by insult, but by facts, history, and a sentence that left no room to escape. Crockett slowly gathered her papers. The soft sound of pages sliding together felt final. She closed the leather portfolio with quiet control, stepped back from the podium, and turned away without looking over her shoulder. The moment the gavel ended the session, the courtroom silence didn't fade. It exploded outside. Within minutes, video clips of Crockett's final sentence flooded social media. Every major network pulled the footage and began looping it nonstop. On cable news, split screens filled the airwaves. Crockett on one side, Alito frozen in silence on the other. Anchors replayed the interruption, the document reveal, the data strike, and the final line over and over. Headlines rolled across the bottom of screens. Supreme Court clash shocks Washington. Crockett confronts Justice Alito in explosive voting rights hearing. A single sentence that stunned the court. The story wasn't slowing down. It was multiplying. Legal analysts rushed into studios arguing in real time. Some called it the boldest courtroom performance in years. Others tried to downplay it, but even they couldn't ignore the reaction. Conservative commentators attempted damage control, claiming Crockett was grandstanding, but the video kept undermining that narrative. Every replay showed the same thing: calm delivery, hard evidence, and a justice left without a response. Originalist scholars were suddenly forced onto defense panels, explaining why the historical documents she presented couldn't simply be brushed aside. For the first time in a long time, the debate wasn't about political spin. It was about constitutional receipts. Then the legal world caught fire. Within days, the written filing behind Crockett's argument, quickly dubbed the Crockett Brief, began circulating through law schools, judicial chambers, and legal forums. Professors assigned it as required reading. Research groups broke down its historical citations line by line. Harvard Law Review announced a special analysis issue dedicated entirely to the arguments she introduced. What had started as one tense courtroom exchange turned into a national case study almost overnight. By the end of the week, one thing was clear. This wasn't just a viral moment. It wasn't just a media storm. The Crockett Brief had become a legal blueprint, and the entire constitutional conversation had been forced onto new ground. In the weeks leading up to the ruling, Washington felt like it was holding its breath. Anonymous leaks began circulating through legal circles, hinting at a divided court and a possible surprise outcome. Cable news ran countdown banners. Reporters camped outside the marble steps of the Supreme Court before sunrise. Microphones ready. Cameras pointed at the closed doors like they were waiting for a verdict in a national trial. Inside, clerks moved with unusual tension, carrying sealed folders down quiet hallways. The public sensed it too. This wasn't going to be a routine decision. When the opinion was finally released, the shock hit instantly. A 6-3 ruling. The contested voting law was struck down. The court announced a new standard. When election rules create measurable disparities in access to the ballot, courts must apply heightened scrutiny. Phones lit up across the press section. Anchors stumbled over their words, trying to read breaking updates live. And then came the line that made the room erupt. Chief Justice John Roberts had written the majority opinion. His words were firm and unmistakable. The Reconstruction Amendments, he wrote, fundamentally reshaped the balance of power between states and the federal government, and courts could no longer ignore that shift. In one moment, the legal ground under voting rights changed. Outside the building, the announcement landed like thunder. Cheers broke out on one side of the steps. Shocked silence spread across the other. Social media exploded again, this time with one clear message repeating everywhere. Crockett's argument didn't just influence the case. It rewrote the rules of the fight. Then came the second shock. When analysts opened the concurring opinions, they froze. Justice Alito, the same justice who interrupted Crockett, dismissed her data and challenged her authority, had not written a dissent. Instead, he issued a concurring opinion that stunned the legal world. While still defending state authority in theory, he acknowledged that the Reconstruction debates presented in this case revealed constitutional limits he had previously minimized. It wasn't a full surrender, but it was a retreat, and everyone saw it. Former allies reacted immediately. Conservative commentators accused him of backing down under pressure. Legal hardliners criticized him for watering down state power arguments. On talk shows, analysts replayed his courtroom confrontation with Crockett side by side with his new written words. The contrast was impossible to miss. The justice who tried to control the conversation had been forced to adjust his position publicly. His credibility took a visible hit, not because he lost a vote, but because he lost control of the narrative. In legal circles, the message was clear. The interrupter had become the one adapting. The courtroom power dynamic that flipped during the hearing had now flipped permanently on paper. The fallout didn't stop with the ruling. 2 months later, the Supreme Court announced the first binding code of judicial conduct in its history. New restrictions on public political speeches, stronger recusal standards, clearer ethical boundaries. Officially, no one credited Crockett. Unofficially, everyone knew what triggered the pressure. Her confrontation had exposed how public commentary could undermine judicial neutrality, and the institution was forced to respond. Across the country, state legislatures quietly began revising voting laws. Some adjusted ID requirements. Others expanded access points and early voting options. Jefferson County became the clearest example of the impact. In the next election cycle, voter turnout surged. First-time voters lined up in record numbers. Community organizers shared photos of long lines, not of people being turned away, but of people finally being allowed in. What had started as a courtroom argument now showed real-world results. Law schools followed quickly. The Crockett Brief became mandatory reading. Clinics launched new research programs focused on historical constitutional records. Students weren't just studying the case, they were building strategies around it. The system had shifted, and it wasn't going back quietly. 2 years later, Jasmine Crockett walked back into the Supreme Court building for another case. This time, the atmosphere felt different. Clerks offered silent nods as she passed. Security guards recognized her. Even the air inside the chamber felt calmer, heavier with awareness. When she stepped to the podium again, no one interrupted her opening sentence. No sharp cuts, no dismissive tone. Just attention. For a brief moment, the memory flashed back. The earlier hearing, the interruption, the tension, the silence, the document drop. The contrast was powerful. What once began with a public shutdown now opened with quiet respect. Crockett stood steady, the same posture, the same calm presence. But the room around her had changed. One interruption had triggered a constitutional turning point. It reshaped legal standards. It forced institutional reform. It altered how power behaved inside the highest courtroom in the country. And long after the cameras stopped rolling, the message remained clear. When the Constitution is challenged, sometimes all it takes is one voice, one moment, and the courage to refuse silence. If this moment shocked you, inspired you, or made you rethink how power works inside America's highest institutions, make sure you don't miss the next story. Hit subscribe, turn on notifications, and join this channel as we continue exposing the confrontations, turning points, and hidden battles that shape our democracy. Your support keeps these stories alive and the truth moving forward.